I'm Andy Panko, owner of Tenon Financial. Welcome to Retirement Planning Demystified. When you have a tax-deferred retirement account like a traditional IRA or 401k, your withdrawals will be subject to income tax. Also, if you're younger than 59 and a half when making the withdrawal, you'll generally have to additionally pay a 10% penalty. But thankfully, the IRS grants a few exceptions to that early withdrawal penalty. And one of those exceptions is known as the Rule of 55. I'm about to explain what it is and how it works. But before we start, remember this video is only general explanations and education. It's not specific tax, legal, or investment advice. Before considering acting on anything you see in this video, first consult with your tax, legal, or investment advisor. If you have a tax-deferred retirement plan through your employer, you may not have to wait until you're 59 and a half to take penalty-free withdrawals from the account. Specifically, you may be able to take money out as early as the year you turn 55, thanks to something referred to as the Rule of 55. In order to qualify for penalty-free Rule of 55 withdrawals, you need to have a separation of service from your employer in the year you turn 55 or later. For example, assume you have a 401k with your current employer, and you will turn 55 this calendar year. If you have any sort of separation of service from that job this year or later, you may be able to take penalty-free withdrawals from that account starting this year. And any sort of separation of service can qualify you. It doesn't matter if you're laid off, fired, or simply quit. So long as your separation of service happens in the year you turn 55 or later, you may be eligible to use the Rule of 55. It's important to know that not all employer plans will actually allow you to do Rule of 55 withdrawals though. Even though the IRS allows it, that doesn't mean your particular employer plan does. The Federal Thrift Savings Plan, or TSP, allows the Rule of 55, but not all 401ks or 403bs do. So how do you know if your plan allows it? Well, the best thing to do is read through your plan's documents or simply ask your HR department or plan administrator if the Rule of 55 is allowed. Also, you can't use the Rule of 55 from the retirement plan of an employer from which you had a separation of service prior to the year you turned 55. As an example, assume you're currently 55 and you still have an old 401k from a job you left when you were 50. Even though you're now 55, you can't use the Rule of 55 from that previous employer's plan because you left there before the year you turned 55. Furthermore, IRAs do not allow Rule of 55 distributions, which means if you separate from service from your employer in the year you turn 55 or later and think you may want or need access to some of your money in the retirement plan at that employer prior to turning 59 and a half, do not roll that account into an IRA, or at least if you do choose to do a rollover, leave behind in the plan the money you think you may need to access before 59 and a half. Even though IRAs and retirement plans of employers from where you separated prior to the year you turned 55 are not eligible for Rule of 55 distributions, that doesn't necessarily mean you can't get penalty-free access to those monies before age 59 and a half. For example, assume you're 56 and you currently work at an employer whose retirement plan does allow Rule of 55 withdrawals. Also assume you plan on retiring from that job within the next year, well before 59 and a half. If that plan allows outside money to be rolled into it, you could potentially roll in money from your IRA or from other old employer plans you may have from previous jobs. Once such money is rolled into your current plan, that money will then be eligible for the Rule of 55. There's also a slight twist on the Rule of 55 known as the Rule of 50. As you probably guessed, the Rule of 50 means you can potentially take penalty-free withdrawals from your employer plan starting in the year you turn 50. But the Rule of 50 applies only to certain qualified public safety employees such as federal firefighters, law enforcement officers, and air traffic controllers. One of the biggest things to remember with the Rules of 55 or 50 is that they only get rid of the 10% early withdrawal penalty. They do not get rid of the requirement to pay income tax. All of your tax-deferred distributions, including those done under the Rules of 50 or 55, will still be subject to federal income tax and potentially state income tax depending what state you live on. So plan accordingly when taking any distributions from your tax-deferred retirement accounts. Well, that's it for the Rule of 55. I hope you found this video helpful. If you haven't already, subscribe to this channel so you can be the first to know when new videos are posted. And don't forget to subscribe to my monthly newsletter, Retirement Planning Insights, which provides informative retirement planning tips and info. Also, be sure to join my free Facebook group, Taxes and Retirement, where you can learn all about tax-efficient retirement planning. Thanks for watching. I'll see you soon.